Welcome to the Family Law Channel. The Supreme Court has ruled unanimously that police must obtain a search warrant before using a GPS tracking device to monitor criminal suspects. Questions still remain, however, about how technology has changed and individuals' expectation of privacy. My guest is the host of the Family Law Channel, the Honorable Judge Eugene Hyman. Welcome back, Judge.
Thank you.
So this was a unanimous decision, which is sort of unusual here, and it really only goes to it addresses the trespass aspect of applying a GPS device to an automobile.
Right. Right. About the only thing that the nine of them agreed on is that this was a trespass and it was a search. Now, this doesn't mean, given the Supreme Court's ruling, that the case is automatically thrown out. What happens is it goes back to the courts below to decide whether or not there is sufficient evidence, lawful sufficient evidence, to be able to prove the case beyond a reasonable doubt, now that certain evidence will probably be excluded. What the Supreme Court decided, as I said, is that there was a search. It's now up to the government to be able to prove that there were exigent circumstances that relieved it from the warrant requirement. Interestingly enough, my practical experience, and I believe the practical experience of most judges, federal and state, is in these kinds of cases, they go ahead and they get warrants. This is not going to be as arduous a requirement as some police commentators are saying. It's routine to get warrants, not just with respect to the placement of GPS devices, but also with respect to getting telephone records. I mean, you sign those every week in state court. With respect to a gang case or a murder case, they're going to be getting cell phone records, including the cell phone towers that where signals went through. I mean, this is routine. This is a no-brainer.
Justice Alito and Justice Sotomayor had some interesting things to say about this. Let's talk about the constitutional aspects of this and looking at someone's expectation of privacy, how it has changed in the digital age. Back when they were drafting the Constitution in the 18th century, 20 years ago, if you were going to provide some sort of surveillance on a suspect, you had to get a team of agents together and they had to sit there for 2 weeks, and it was very expensive. Well, now, even looking at this particular case, putting a GPS device on a vehicle isn't necessary, really. One can just look at your cell phone and track that. I mean, there's all kinds of things, all kinds of ways that the law enforcement could track you. Justice Alito or Sotomayor had said that maybe we need to adjust the Fourth Amendment to allow for some changes regarding now what our expectation of privacy is here in the digital age.
Correct, but unfortunately, the Supreme Court didn't really give much advice in that regard, which is their practice. That's one of the practices of courts in general in the United States, is they only rule squarely on issues that are before them. And even though we all know that certain issues are in fact going to come before them because of conflicts in the appellate courts and conflicts amongst the states, they're not going to address or give a hint until, in fact, that issue is squarely before them. So the issue will come down to whether or not the fact that each of us knows that our phones have GPS devices in them, does that automatically mean that law enforcement without a warrant is going to be able to follow us around with assistance from telephone companies? Number one, the average telephone company is not going to do it without a warrant because they're afraid of being sued. So the reality is that they're not going to do it without a warrant. Number two, remember, you have the federal secret warrants under post-9/11 legislation, where you go to a special federal judge who issues a secret warrant that isn't in court files that are accessible to the public. In which case they're still getting a warrant, and warrants are just not that difficult to get. You just have to allege by a reliable person that there's probable cause to believe that a felony has occurred, and that a particular individual or individuals are involved in the committing or the continuing committing of a crime. It just isn't that difficult.
Yeah.
The underlying problem in this particular case is severalfold. Number one, they did have a warrant, but they applied it after the expiration of it, and they applied it outside of the jurisdiction where the warrant had been issued. So, I mean, this sort of reminds me of the most recent 49ers versus the Giants. I mean, they just kept fumbling the ball. This was not a difficult situation to really understand, which is why 9 of them agreed in terms of the outcome.
Well, we appreciate your time and your expertise in this area. Very good conversation, Judge Hyman.
Thank you.
You're watching the Family Law Channel here on the Legal Broadcast Network.